For those of you who have worked with us and when we've done estate planning with you, you know we talk a lot about the importance of these fiduciary positions and making sure that you choose people who you are confident and comfortable with in terms of them being able to handle the role and to be able to do the things that you've asked them to do within the important documents that we're going to talk about. So why don't we go ahead and get started, and let me first talk about, the general documents that we're going to be touching on today. We're going to be talking about your healthcare proxies, the powers of attorney, when you're a personal representative under someone's last will and testament, if you are acting in the capacity as a trustee or you have been named as a successor trustee, so you're not quite in that position yet, but might be taking that over at some point in the future. And then I'm also going to talk about guardianships and conservator or conservatorships as well, and what the role is of both a guardian and a conservator. So there's two things that I want you to think about as we're going through these different fiduciary positions, is that there's two different kind of legal thinking or legal reasoning behind how the fiduciary is supposed to be acting. And one is whether they are acting in the best interest of someone, meaning that the decisions that they are making are based on what is best for the person for whom they are making the decisions. They're using the pros and cons, weighing the risks of the benefits versus, the disadvantages to doing something, or whether you're using what we call substituted judgment. Substituted judgment is different than best interest. This is where you are stepping into the shoes of an individual. And in particular, you're going to hear me talk about this a lot with respect to healthcare proxies. This is where you are making decisions for the individual based on what they would want, which may or may not be in their best interest. For instance, we always use the case of someone who may refuse a certain medical procedure or a medical intervention based, let's say, on religious beliefs. Now, based on the outside world, the best interest may be to accept that is going to be more advantageous for the person. But if you are acting as in the capacity of a fiduciary and you are to be using the substituted judgment standard, then you're stepping into that individual's shoes and you're doing what they would have wanted to have done in that circumstance, whether it's in their best interest or not. So a couple of just terms to remember as we're going through this. So let's start with the healthcare proxy and exactly what a proxy is. When you are in the position of being a healthcare decision maker for someone else, you are stepping into their shoes, or you should be. You should really take some time to get to know what the person who's asked you to be in this position would want to have done in certain healthcare situations. So it can be really helpful to actually sit down with the person, talk with them about what they want, maybe go through some scenarios. We have a wonderful ebook that talks about how to have a conversation with a loved one about their healthcare wishes. If you would like a copy, just reach out to Carol. But it kind of walks you through some of the things to think about. There's also a wonderful document that's available on the internet called The 5 Wishes. This again is a really helpful document that will walk you through different scenarios to talk with the person who has named you as their proxy, so you better understand what their wishes are. Because again, you are using substituted judgment when you can, not best interest. Now, of course, if there's a circumstance in which you don't have any idea as to what the person would want, then you may fall back to kind of that best interest standard and make the decision based on conversations with healthcare providers, maybe other family members, people who know this individual, and be able to give you some direction, some framework for the decision that may need to be made. So if you're asked to be in the fiduciary position as someone's healthcare proxy, again, communicating with the person who's named you in their document is critical so that you can understand where they are coming from in terms of their wishes. particularly end of life types of discussions. What would happen if you ended up needing advanced life support in order to be able to have life maintained? Is that something that you would want? What are the parameters in terms of decision making? I remember my in-laws having this conversation, and the two of them actually put a time frame around it. They had promised each other that they would not make a decision to unplug or not use advanced measures until 72 hours had passed. That was kind of just pulled that out of the air, but it was a standard that helped both of them feel more comfortable. And it gave framework to the people who would be acting that position of healthcare proxy for them. As the proxy, you're going to need to have good communication skills. You're going to want to have good advocacy skills, because you're going to be in the position of advocating for this individual. Remember, your position as the healthcare proxy is only activated when they no longer are in the position to make healthcare decisions for themselves, because they're incompetent or they're incapacitated in some way. So you're really going to be stepping into their shoes and advocating for what is really necessary for them and what they would want should they be able to speak for themselves. Certainly you want someone who's trustworthy. That goes without saying. You want somebody who is going to pay attention to what's important to you and act appropriately. And they have to be able to make a good decision. So, oftentimes someone is not good at decision making. They just can't come to a decision about a certain circumstance. So if you're acting as the proxy, decision making is going to be very critical. You're going to need to make tough decisions. And sometimes you're going to have to make those decisions a little bit in a vacuum. So good communication skills, talk with the healthcare providers, find out what the situation is really like, what the alternatives are like, and hopefully you've had an opportunity to be able to talk to the individual for whom you're making these decisions ahead of time, so that you understand what's important to them. So healthcare decisions are critical, and making sure that we've appointed somebody in this position who has these skills and will act on our behalf, or if you're the person acting as the fiduciary under a healthcare proxy, you want to make sure that you have done your homework ahead of time. It would make it much easier should you have to step into their shoes. So very much akin to healthcare proxies, powers of attorney are really focused on having to step into somebody's shoes and manage all of their affairs other than healthcare. And in most circumstances, this is really a financial tool. It allows the individual to be able to access bank accounts, to be able to manage investments, to be able to pay bills, all of those kinds of things. It can even go so far as to allow someone to make gifts on your behalf, to be able to set up trusts on your behalf. And so powers of attorney are very broad-based documents, very powerful documents. If you've been asked to be someone's attorney in fact, to be functioning under a power of attorney for them, remember that there is two ways that the power of attorney can become activated. One is that the day the person signs it, it's already activated. So it allows you as the fiduciary to be able to utilize that power of attorney to help them out without having to go through any additional steps. For instance, you don't have to show that your loved one is incompetent or incapacitated in order to function under the power of attorney in this circumstance. You may just be able to take that to the bank and say, they've asked me to help them out. I want to, now act as their as their power of attorney and be able to help them manage their finances. Now, the other type of power of attorney is called a springing power of attorney, and it requires something to activate it. And the document will actually explain how this will happen. And typically what we see is the document requires medical documentation, like a letter from the individual's physician, to say that they are no longer capable of handling their financial affairs. Now, we tell our clients that utilizing that kind of document can help to give them just a little bit level of reassurance that nobody is acting as their attorney in fact, unless there's a reason. but it can put a big hurdle in the way of the attorney in fact to actually be able to get the document activated. We see in practice all the time how difficult it is sometimes to get medical professionals to be willing to write those letters to say that someone is no longer competent or capable of being able to manage their own affairs. And that can really hold up the attorney in fact being able to step forward and manage the individual's finances. And so there can be a big delay. But some things to know if you're in the position of being the attorney in fact under the power of attorney is you want to make sure that you understand finances, that you can balance a checkbook, and that you understand just the basics of things like investments and asset management. Now, certainly know that you can always hire professionals to help you with that. As a matter of fact, we highly recommend it in many circumstances that you work with a qualified financial advisor. Depending on the amount of assets and their value, it's critical that you make decisions as the attorney in fact that are for the best interest of the individual that you are dealing with. And so you want to make sure you make prudent investment decisions, that you're not putting their money at risk. And we'll talk more about this when I talk about acting as a trustee, but that's critical when you're handling somebody else's finances, that you are not putting their finances at risk in terms of investment decisions that you may be making. So for instance, if you are somebody who says, hey, I'm going to go ahead and buy all kinds of individual stock for this person as part of my job as their attorney in fact, that's an incredibly risky investment situation. Even though today's world, the market has done so well in many circumstances, you never know, and you never would want to utilize that strategy without being very clear as to the risks and benefits as to what you're doing. So working with a financial advisor, somebody who is well seasoned in handling finances, is critical. You also may need to work with some other types of advisors, possibly insurance advisors, bankers, of course, being able to make sure that you understand what asset holdings the person has and what exactly are your responsibilities. So for instance, if someone owns a rental property and they now no longer are in the position of being able to manage this for themselves, and you're stepping into their shoes as their attorney in fact, you now need to decide how to properly manage that rental property. Again, using professionals is always something you can do. So maybe it would be appropriate for you to hire a management company to take care of those rental properties, because this is out of the realm of your comfort zone and of your knowledge zone. And so knowing what your limitations are, what your skills are, is going to be really important so that you can do the best job possible for the individual on whose behalf you are acting. It's also very critical that you read that power of attorney carefully. Most powers of attorney are very broad in terms of the authority that they give, but sometimes they can have restrictions on them. For instance, if you're acting as the fiduciary for somebody, as the attorney in fact under a power of attorney, and you decide, you know what, it's appropriate for me to go ahead and give gifts to this person's children. They did it all the time. This was something that's a tradition of theirs, and so I'm going to give a gift out. You need to make sure that the power of attorney allows you to give those gifts and that it's something that's been authorized in the document. Another thing you have to be careful about, because you have a fiduciary responsibility, the person who is acting as the attorney in fact is not supposed to benefit themselves in their role. So for instance, if I were being named as someone's attorney in fact, I am their legal attorney, but they've asked me also to function as their attorney in fact under their power of attorney. and we found it was appropriate to make gifts to their beneficiaries, we certainly don't want that authority for me to make gifts to myself. And so as a fiduciary, I could not do that. I could not make gifts to myself. That's not appropriate. But what if you've asked one of your children, or you are the child of someone and you are acting as their attorney in fact? And again, it's appropriate for you to be making gifts from their estate. When you do that, you have to make sure that the document allows you to be able to give gifts to yourself as well. Because in that circumstance, most likely they would want you to be able to gift yourself if you're gifting off to your siblings, let's say. They want you to be made whole as well and to be able to receive that gift. So very, very important that we see that power in the power of attorney document. Another a place that we sometimes see issue, if we have a spouse acting as the attorney in fact for someone, and we are doing some advanced planning, let's say we are doing Medicaid asset protection planning, and based on that plan, it's appropriate to go ahead and transfer, let's say, their home from a jointly held situation, husband and wife owning that, the spouses owning that home, to just one of them. In order to do that, again, if we are looking to transfer that property, let's say from a husband and wife, and the husband is now incompetent, and the wife is acting under the power of attorney to make that transfer, we need to make sure she has the authority to self-deal and to actually be able to transfer that to herself. So we always want to look at the documents carefully, understand exactly what the scope of the power is under the documents and what the limitations are, and that if we need to go ahead and make any kind of gifting or transfers, that authority is in the document and allowed. Or if it's not in the document, is there a reason why that limitation is in place, such as if I, as an attorney, were acting as someone's attorney in fact under their power of attorney, they wouldn't want me to do something like be able to gift to myself. Certain characteristics of the power of attorney, you want to make sure that you're, again, listening well when you're talking with the person about taking on this position, so that you understand the scope of what they're asking you to do, that you've read the document carefully and reach out for help when you need it, that you're willing to reach out for help around finances, if you need help to understand insurances, managing property, anything that may come under the skill set. You want to make sure that if you don't have those skills directly, that you reach out to professionals to help you. A critical piece for the person who's acting as the attorney in fact is that they're trustworthy, because you're being given a lot of authority to manage somebody else's financial affairs and really to manage all affairs for them but healthcare. And so you want to make sure that you yourself are trustworthy, and if you're putting together a power of attorney, that you've chosen somebody who you have the utmost faith in that they will do what is appropriate. Unfortunately, we see in our practice when things fall apart, and there is no guarantee that someone under a power of attorney won't be a bad actor and do something inappropriately. Now, certainly there are legal challenges that can be made to that situation, but if they've taken the money, it can be very difficult to get the money back. So being trustworthy as an attorney in fact is extremely critical. Again, understanding money management skills, being organized in what you do, and being able to make very clear decisions. If you're acting as the attorney in fact for somebody and you have, let's say, other siblings that maybe, you're one of the children in that position, but you have other siblings, you want to be able to be forthright with those other siblings, other people who may be involved, so that nobody is thinking that something inappropriate is going on behind closed doors. It's really important that you keep good records and that you're able to explain your actions in case they come up as a question. So the attorney in fact role under a power of attorney is a critical role. We want to try to get somebody in place before there's a need for it, before the individual becomes incompetent or incapacitated. But it's a very powerful role. It's one that has a lot of responsibility that comes with it.
Kathleen, we have a question.
Sure.
How much should optics count? Gifts are allowed to beneficiaries, but self and nuclear family would get more overall than another beneficiary, could create problems with equality or, as you say, sibling rivalry early.
Absolutely. And this is where, one of the things that I talk about with people who are in these fiduciary positions, like the powers of attorney, the attorney in fact, or if you're the trustee of a trust, or even the personal representative of someone's estate, we really encourage people to communicate with the other beneficiaries, to make sure people know what's happening. Now, that doesn't mean that you have to get their permission for everything that is done. That's not what we're talking about. We're talking about being a little bit of an open book in terms of how finances are being dealt with, so that you are kind of taking care of these questions beforehand. You're removing that secrecy that oftentimes happens. Where we see the worst case scenarios is when someone is acting as another's attorney in fact, and they refuse to give any information. That immediately causes people to get their backs up, to get concerned. What's happening here? Now, there may be situations in which it is appropriate. There may be certain decisions that should be made, that should be private. Those you have to think through. You really have to think through, can I share this information? And if I can, how am I going to go about sharing this information? Or is this something that really needs to be kept private, and why? So that's kind of a decision-making role that the attorney in fact has to make, and has to weigh the pros and cons. But I would absolutely encourage people to share information where they can. Sorry about that. My video went off for a moment. Any other questions, Carol?
No, that's it for now.
Let me know if that didn't answer the question, whoever asked that one.
Okay.
So let's move forward now and talk about healthcare proxies, powers of attorney. These are people who will step into someone's shoes while the individual is still alive, but their authority will end when the person dies. And that's where the last will and testament will oftentimes take over. So a last will and testament, we talk about it as being an instruction sheet. This is where the person, the decedent, has provided instructions as to how they want their estate to be managed after their death. And this is really controlling assets that the person owned individually that didn't have any named beneficiaries. So this is the bank account that they had in their own name, the investment account, their property, a home, a second home that they owned themselves. When they die, we don't know what to do with it. And so the role of the personal representative now will kick in. The first thing is that this person has to do is make sure that the last will and testament has been approved or adjudicated by the probate courts as being the person's last will and testament, and that they have received authority from the courts to be able to go ahead and take on this role as the personal representative. The job of the personal representative is typically to then gather all the assets once they have the court's approval to move forward, gather all the assets of the individual, pay legitimate bills of the estate, and then be able to then follow the instructions about how the estate should be distributed that will be in the last will and testament. So you want to make sure, like the power of attorney, that you've read that document carefully and that you understand how things are to be handled and what should go to what beneficiaries, charities, etc. There's some other things that the personal representative has to think about. They also have to think about, have taxes been taken care of? Are their taxes going to be levied against the estate or the individual themselves? And that those taxes are properly managed and paid. That is a job for the fiduciary as personal representative. They also want to make sure that they're keeping really good records of all of the things that they're doing. So assets that they're bringing into the estate, they need to make sure that they properly understand their value and that they claim them for the estate. They also then need to make sure that all of the legitimate bills are paid and that they account for those bills. Because one of the things that they'll need to do as they're wrapping up the estate, and most times we see that this job lasts about 18 months. They have to keep the estate open for 1 year after the individual has died to let creditors come back at it. And then it can take usually about 3 to 6 months to finally get everything wrapped up. But they'll have to do an accounting. And that accounting is done not only to the beneficiaries of the estate, so that all of them know exactly what came in the estate, what bills were paid out of the estate, and how their distribution was calculated. But they also need to account in many instances to the court so that they can close out this estate and be done with their fiduciary responsibilities. And so you need somebody who, again, is highly organized in terms of being able to manage financial assets and assets of any kind. They have to be trustworthy, because very much like the power of attorney, you've got somebody who's dealing with money and items of value. They need to be able to manage that money appropriately, manage those assets while they're under the personal representative's control, and they have to be very good at decision making. Depending on the family dynamics, on the dynamics of the beneficiaries, there can be a lot of pressure put on a personal representative to get money paid out of the estate sooner than maybe it should be, before they've been able to pay those taxes and make sure that everything has been properly accounted for. People may put pressure on them to, give them a larger share, or to try to argue, I know it wasn't written in the will, but this loved one promised me that they would give me this valuable item or this money. And so it's really critical that that the personal representative is able to kind of hold their ground and ensure what has been told them to do in the will is followed. So personal representatives have a really critical role to play here. And their job, again, usually has a time frame around it of about 18 months or so. So let's talk about trusts. Trusts tend to be a little bit of a different animal here, because unlike healthcare proxies, powers of attorney, which, as we talked about, were while the person is still alive, and wills taking over while the person, after the person has passed, trusts can be in effect both during life and after life. And a typical trust is written to, in many ways, take the place of a will. And that's really the goal of it. A properly managed and funded trust will make it so that when an individual passes away, they won't have assets in just their name. They will have moved those assets, hopefully, into the trust, and so that the trust owns them and controls them at their death. So the role of a trustee will depend on a couple of things. First of all, it depends when you're coming into the role. If you're coming into the role while the individual is still alive. So let's say this individual had put together a revocable or revocable trust, one that was for their benefit and while they were alive, but they have now become incompetent and can no longer manage their affairs. The successor trustee will step in to start managing things for them, even though they're alive. So in this instance, the successor trustee is managing the assets for the benefit of the individual who put the trust together. So their job is to make sure that the decisions they make under the trust are for the benefit of that individual. And again, they have to make sure that they are handling the assets appropriately. Many of the same things that we talked about under the durable power of attorney, that they are able to invest those assets appropriately, As a matter of fact, we have a thing here in Massachusetts called the Prudent Investor Standard, meaning that you are making investment decisions that are prudent, that are comparable to how someone else in the same circumstances with the same level of experience would make those investments. So using professionals to invest when appropriate is absolutely something that we recommend. You have also responsibilities when you're acting as the trustee to account for what you're doing. So very much like under the last will and testament and even the power of attorney, you're going to need to provide accountings to say, this is the assets that I'm managing. Here are all the legitimate bills that I've paid during a specific time frame, and here's what remains. And you want to be, again, as transparent with your job as you can be in this position, because you want to make it so that you're removing those questions about whether you're doing things appropriately or not. Like the power of attorney, you want to make sure that you read this trust document carefully, because it's going to give you all the instructions. It's going to tell you, can you make gifts? Can you make gifts to yourself? Can you self-deal? For instance, if the trust has property, a house, and let's say let's give the example of it, there's a home down on the Cape that's part of the trust. And in this circumstance, the individual who wrote the trust, the grantor of the trust, has now died. And the 4 children who remain are the beneficiaries of the trust. One of those beneficiaries is also acting as the trustee. And the decision is, we can't keep the property. We need to do something with it. It needs to be liquidated and it needs to be sold. The document, the trust document, is going to outline, can one of the children buy the property? And what does that look like? How do they go about purchasing that property? Can the trustee be the person who purchases that property? And what does that look like? So the document itself can provide many of the answers to how things should be managed, how things should be distributed after the individual has passed away. So the trustee needs to understand, who are the beneficiaries, who do they owe the responsibility to, and when do they owe that responsibility. And we want them to be as open and transparent with their transactions as they can be. So a good trustee is somebody, again, who is either good at managing money or willing to get the help that they need to make sure that it's managed properly. Somebody who can work with others, like other professionals, attorneys oftentimes, accountants are involved, investment managers may be involved, financial planners. The trustee needs to keep really good records about the moves that they're making, the decisions that they're taking under the trust, so that if they need to explain, or certainly when they're providing that accounting, that they are giving good explanation for what they have done. They need to be trustworthy, because like the power of attorney and the last will and testament, this person is oftentimes dealing with monies, whether it be actual cash investments or property. And you want to make sure you've got somebody who's going to be trustworthy in terms of their dealings. They have to be able to use good judgment. And we also put in there, they have to be compassionate, because again, this is not an easy role. And depending on the type of trust, they may be making decisions about distributions to minor children or for the benefit of minor children, or distributions to people who may have some kind of special need or disability. Carol, is there a question?
There is a question. Can you clarify what a successor trustee is?
Yes. So typically in a trust document, we have named the primary trustee, somebody who is acting as the original trustee in the document. And for revocable trusts, those are oftentimes the person who's created the trust. So again, in my example, let's say mom and dad create a trust. Typically, mom and dad are the primary trustees. They're the first trustees. But they will name in the document who they want to succeed them. And that person will succeed them under a couple of different circumstances. One will be if the primary trustee becomes incompetent or incapacitated for some reason. So they're still alive, but they're not able to take on the role as trustee anymore. And now the successor must move forward. Another time that we see a successor named is after the individual has died. So again, no longer able to function in that position as trustee, now a secondary trustee, the successor, will step forward to manage things. We also can have successors come forward when a trustee has decided they no longer want to act in that capacity. So remember, this is not an example of indentured servitude. You can't be forced to act in any of these positions. You always have the right to resign and to say, I no longer want to do this. And then whoever is named after you as the successor will be able to step forward. If the document doesn't name a successor for some reason, so it's been forgotten or omitted for some reason, or already you've gone through all of the potential successors and now there is no one else named, the document usually provides instructions as to how that successor trustee will get named. If it doesn't, then there are regulations in Massachusetts under the Uniform Trust Code that talk about how a trustee will get named and placed. But you'll often find the document itself gives the direction. So I hope that answered the question. Let me know if it didn't.
Sounds good. Thank you.
And now I want to talk about two other kind of areas where we see fiduciaries. And this is in the guardianship arena and the conservatorship or conservatorship arena. And these are, when someone is stepping in as either a guardian or conservator, it is usually because the estate planning or the wishes of the individual for whom these proceedings are occurring for did not provide direction. They didn't do a power of attorney, or they didn't do a health care proxy. And sometimes we find even if they did do something like a power of attorney, if the document was not broad enough, did not give enough appropriate authority, it may be that we have to seek a conservatorship for certain reasons, and I'll explain what that is. So one of the main benefits of having powers of attorney, having healthcare proxies in place, is that we avoid oftentimes the involvement of the courts. And when we get the courts involved, it just adds another whole layer. First of all, these are expensive proceedings to go through. They are public proceedings, meaning that things about someone's underlying competency, their underlying health issues can oftentimes end up in the public realm. They are proceedings that take time. The probate courts are incredibly overtaxed, particularly in this COVID environment. And we find that these proceedings really can take a large amount of time and certainly a large cost. So we really encourage people to put powers of attorney and healthcare proxies in place. Also, healthcare proxies and powers of attorney allow the individual to choose who they want to be their fiduciary, to be the individual who's going to be taking over these decision-making points, should it be necessary. When we have guardianship and conservatorship proceedings, you as the person who is no longer competent has no control usually over who's going to be placed in that position. And so it may be somebody who you would not otherwise want to be acting on your behalf. So let's just talk a little bit about first guardianships and how that works. So I often think of guardianships as being very akin to healthcare proxies. This is the person who is stepping in to make decisions for someone about everything but financial, and it is a court-appointed person. And when I talked about those standards that we use, in most instances under the guardianship, we are using what is called the substituted judgment standard. We want this person to be stepping into the shoes and, where possible, making decisions based on what the individual themselves would want if they could make these decisions for themselves. Again, guardians take time to get in place, and there is court oversight into everything or most of what the guardian does. And so if the guardian needs to do things like make decisions about placement of somebody in a nursing home facility or into a psychiatric care facility, those things need additional court approval. Also for the use of antipsychotic medications, which can be very commonplace when we have someone, let's say, who's dealing with a form of dementia, something like sundowners, etc. The use of antipsychotics can be very beneficial to them. But we have to get additional court authority for a guardian to be able to allow the use of that medication. And so guardianships are something that require a lot of time to put in, a lot of energy. They're costly. There is ongoing court oversight. The guardian has to give an annual report to the court about the well-being of the individual whom they are overseeing. And they oftentimes have to go back to the court to get authority to make decisions. Things like end-of-life decisions, those need to go back to the court in order to be approved and allowed. So avoiding the guardianship when possible is really the goal, but sometimes it's not possible and we have to have a guardian put in place. One of the places where we see guardianship proceedings come in, and actually there is a kind of, I call it a little bit of a shortcut to a guardianship proceeding, is when someone has a health care proxy that they have put in place. Remember, health care proxies, as well as powers of attorney and these other documents, are revocable by the individual at any time or amendable. And so let's say there is an instance in which someone is hospitalized and they're having some kind of a psychotic issue, and there's a question about their competence. They don't want the person who they've asked to be their healthcare proxy to actually be that proxy. Let's say that person is the one who had them committed to the hospital or had them admitted, depending on the situation, and they're mad at them and they don't want them to be the proxy anymore. There is a proceeding that we can use with the courts to validate a healthcare proxy. And this is where the person who has been named as the proxy will petition the court to say, this person put the document in place when they were otherwise competent and asked me to be their proxy. They gave me the authority to make healthcare decisions for them. They are now not competent. And even though they're saying they would want to revoke this document, I believe that that is not really their wishes. This is actually a result of their illness or situation. And that if they were competent, they would want me to act as their healthcare proxy under this document. And in this case, we do need to still get the courts involved, but we get them involved in a very different way than a full-blown guardianship. We are asking the court in this circumstance to please validate the healthcare proxy and recognize the individual who has been appointed and the authority that's been given under the document. So that's just something to know. There's a way to do that if there's ever a question about the validity of a healthcare proxy. So lastly, I want to talk about conservatorships or conservatorships. This is when someone does not have something like a power of attorney or even a trust with a trustee in place, and somebody needs to be appointed to handle their financial affairs. Again, the individual is adjudicated by the courts as being incompetent or incapacitated and unable to handle their own affairs. And we're looking to have the court appoint somebody to step in and manage that for them. In most cases, this is really a best interest standard that we're using because the person is acting on the benefit of the individual, and they're looking at the pros and cons. They're managing their finances, making decisions about should their house be maintained, should the house be sold, how do we get care for the person and pay for that care, how do we make sure their bills are taken care of properly. Like the guardianship, this is a process, and it is one that again has cost associated with it. It takes time to get a conservator in place. Remember, the person may not be able to identify who they want as their conservator because they're now incompetent or incapacitated. So ideally, having a power of attorney is the better way to go. But sometimes we need to have the courts intervene and the courts act to appoint somebody. Once the conservator is appointed, he or she then will have ongoing responsibilities, not only to the individual whom they're serving, but to the court. They need to give an annual accounting to the court of what they're doing with the person's money. They need to give them a financial plan as to how they intend to manage the money and what issues may be arising. And like under the guardianship, there are often times that we have to go back to the court to get specific authority to do something. For instance, if the decision is made that it is appropriate to sell this person's primary home, let's say, we need to go back to the court. We need to get the court's approval to move forward with that plan. Also, things like taking steps to protect assets. So let's say we have a husband and wife situation and one of them needs long-term care and that person is no longer competent. They didn't do a power of attorney, so we don't have a decision maker in place ahead of time. And we need to transfer the ownership of the primary home from the husband and wife to the wife only in this circumstance as a way of helping to protect the value of that asset. We have to petition the court to get a conservator appointed and to get permission from the court to allow us to make that transfer. So again, these are time-consuming processes. They are costly ones. They involve a court in many of the different twists and turns of what's happening. And that all just adds to the cost of being able to continue. So things to know: avoid the guardianship and conservatorship where possible, but there are times when you need to take those actions and be appointed by the courts to act. All right, terrific. Well, I hope that gave everyone a little bit of an overview and flavor for what these different roles really encompass in terms of responsibilities. And a good feel for why we really do push those powers of attorney and healthcare proxies. Want to avoid the guardianship and conservatorships when we can.